So basically, when a charge reads a public gathering, a prosecutor must take the charge to what kind of a gathering. Is it a meeting? Under paragraph A. Gathering or concourse of 10 or more persons in any public space. So you're not being told, were they 2 people? Were they 1? Were they 3? Because the minimum number is 10 or more. And it must also be in a public place. This charge does not say the public place or any place. We are just being told in Nairobi. All of us in Nairobi. Yeah, even here is in Nairobi. So, which is the public place? So, that way, the offense is not disclosed. Paragraph B. Any meeting or gathering which the public or any section of the public of more than 50 persons are permitted to attend or do attend, whether on payment or otherwise. There is no suggestion, it's not been indicated whether there were 50 people, whether these people paid to be there, they didn't pay to be there. So what is Honorable Kihara'S supposed to defend? These particulars are not in the charge. And finally, the other situation is the paragraph C. Any procession in, to, or from a public place. Any procession moving in or out of a public place. We are not told that these words were uttered in the investigations. When a charge is brought before you, under section 94, under section 134 of the CPC, one thing that should stand out is the following: that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving a reasonable information as to the nature of the offense charged. The information that is contained in this charge is insufficient under subsection 1. It is insufficient under subsection 2 of section 94 of the Penal Code. Would it be right then if I shift to that point? When a charge in the section which I have just referred to, that is section 194, is indeed the section that implements the provisions of Article 50, sub-Article 2, paragraph B of the Constitution, that provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. The charge that is before you does not have sufficient details as defined in the implementing statute. So if she goes ahead and pleads, the judge has brought before you, it will be a violation of Article 50. So Article 2, paragraph. And important to mention, Your Honor, that under Article 25 of the Constitution, and for emphasis, I want to read what it says, that despite any other provision in this Constitution, the following rights and freedoms shall not be limited. These are rights which cannot be limited. And one of such is the right to fair trial. That is paragraph C of Article 25. The right to fair trial is the one that I talked about under Article 50. So you are then placed in a position where you have a charge that is in contravention of Article 50, and you're being asked to allow a person to plead to those charges. Your Honor, decline that invitation. And Your Honor, I do not want to talk much because before we came here, we were before you again in another matter with the same prosecution team and Mr. Gov'T for Honorable Bengori. And yesterday is very late because we were at the DCA headquarters to deal with an issue of Honorable Bengori. And now we went to the other day, then yesterday we were dealing with Jim. And now, so that Your Honor, I do not want to tire you because you're also very stretched. But the context of that is that there's a pattern, and this court should rise to the occasion and see what is happening and uphold the Constitution. And that will be. And I invite my other friend, our chairman, Mr. Wanjohi, to make something.
No, that is not the introduction it is to our chairman. This is our chairman of MATIANG'I, which is an organization of about 6,000 lawyers. So you cannot just give us such an introduction. Please.
Thank you. Well, it's another thing to you're the chair.
We have an association which has about 8,000 lawyers practicing in Kenya, others in Kenya. It's called Kihara'S Association. Very many lawyers.
What he's not telling you is that he has now incorporated our cousins from Mount Kenya South.
Is our Thank you.
For that introduction. Your Honor, again, my name is Wanjohi, and allow me to concur with what my senior, Mr. Kihara'S, said, and what the state is doing. The state is using fire extinguishers to blow out a candle. Section 94 was meant for brawls in bars and fist fights in funerals. That is the purpose of Section 94, the penal code. But, Your Honor, let me go into why these charges before you are defective. Number one, Your Honor, there is no clear offensive conduct that has been identified. Section 84 says the charge itself is offensive conduct conducive to breach of peace, contrary to Section 94 of the Penal Code. Whether the charge does not specify what part of the charge was actually offensive. And a simple reading of these particulars, I will just cherry pick some. I would say I want to talk about Naivasha because I know the goons were transported in NYS bus. How is that offensive? I want to tell the president, this is not about the young people who you went around promising heaven and what you are digging deep so that they go under. It will not happen. How is that offensive? Number two, if the president has been mentioned in this particular charge sheet, he is not among the witnesses. You see the complainant? Second, Your Honor, the use of vague words like offensive conduct without defining how and why it was offensive makes the charge overly broad and ambiguous. Secondly, Your Honor, no particulars of breach or threat to peace has been disclosed. The charge alleges intent to provoke breach of peace, but fails to state the following things. What disturbance followed, if any? Who was provoked? What specific act of violence or disorder was caused or threatened? There is no breach of peace in these particulars that accompany this charge. Third, Your Honor, we submit that speech alone is not automatically conduct. Section 94 is meant to criminalize conduct. It is clear. Offensive conduct conducive to breaches of peace. It does not criminalize opinions and political expressions. If the charge is based solely on speech, then the prosecution must show that the speech had a clear and present danger of causing peace. This threshold, Your Honor, has not been met. Fourth, Your Honor, we submit that no manslaughter is alleged, save for with intent to provoke breach of peace. To which we say the charge does not state intent or even suggest that Jane knew her words would provoke unrest. What she was doing was expressing her political opinions, guaranteed under Article 33. Now, Your Honor, fifth, we want to go to the issues of Article 50, 2B, and K of the Constitution, whereby the accused has a right to be informed of the charge in sufficient detail, presumed innocent, and not to be convicted for conduct that is not clearly defined as an offense in law. Your Honor, this charge is too vague and imprecise to meet these standards. Sixth, Your Honor, there is no link between the words and the alleged offense. Even if this speech was quoted in full, it shows no incitement to violence. Actually, she's even giving her condolences. As I condole with the bereaved, quote, and I also empathize with those whose properties were destroyed. So this speech does not show any incitement to violence or encouragement of disorderly conduct. Condolences, criticism of police, political frustration, how is that a criminal act, Your Honor? And if that was the case, I believe half of Parliament would be in committee. Seventh, Your Honor, as I conclude, this this is a gross misapplication of the Penal Code. As I indicated, this provision is for brawls in bars and fistfights in funerals, and should not be used as a tool to criminalize free speech, however loud or uncomfortable it is. Finally, Your Honor, submit that even if all these alleged facts were true, they will still not amount to breach of peace under Section 94. Which makes the charge fatally flawed and ripe for striking out at the earliest instance. This will submit.
You want to cede the floor for 1 minute to Counsel Iregi, and then
The last one.
yeah, last one. Then I probably just